How do I sponsor my foreign national spouse if both of us have been living overseas? Hi, I'm Jim Hacking, immigration lawyer practicing law throughout the United States out of our office here in St. Louis, Missouri. We have been contacted by U.S. citizens living abroad many times over the last couple of years, and they contacted us because they're interested in bringing their husband or their wife to the United States to live. And there are some special considerations to think about when the foreign national and the U.S. citizen have been living overseas for quite some time. And the main question is whether the U.S. citizen has maintained their residency in the United States. So how do you maintain your residency? One way is to keep paying your taxes, to make sure you pay your taxes every year. But more importantly, you're going to want a location certain, an address that you use every time, and that you maintain connections to your home state, your home city, your home country. And so you want to maintain a bank account, you want to have a valid driver's license if you can, because when the time comes for you to sponsor your foreign national husband or wife, you're going to want to be able to show that you still reside, on purpose and principally in the United States, so that even though you've been living overseas and with your foreign national spouse, you want to now come back to the United States. The big question is whether or not you have abandoned your residency or you're going to have to reestablish your residency. So sometimes when the foreign national contacts us, they literally have not been back to the United States in 3 or 4 years and they've maintained no ties. So in those situations, we ask them to come back to the United States to open a bank account, to find an address or enter into a lease to get ready for when the foreign national comes to the United States. So it's real important to either maintain your residency or to reestablish your residency. And so the process is generally the same once you've been able to do that. We're going to have to demonstrate that you are residing permanently in the United States. And the reason for that is that the State Department and the Immigration Service will be scratching their heads asking, why do you want to get lawful permanent resident for your foreign national spouse when you yourself haven't even been living here? And that's why we sort of have to go through all those hoops. But once we do, we've been able to handle many of these cases, and the way that we do it is we use the U.S. address as the point of contact for the U.S. citizen, and we submit evidence to show that they've maintained their residence. And then from that point forward, it's just treated as if the foreign national is overseas and the U.S. citizen is here in the United States. And we do that by filing the I-130 application with the USCIS, and then once that's approved, it goes through the National Visa Center, and then it's on eventually to the embassy. So in many ways, it's like a traditional I-130 away case. That's what we call these cases, an I-130 petition for alien relative. And then it's all consular processing after that. So the one thing to keep in mind is that you maintain your residence, that you document that you submit proof of that to the USCIS and to the State Department so that everybody feels comfortable in giving your foreign national spouse a green card. If you have any questions about this, or if you're interested in moving forward on a case like this, be sure to give us a call at 314-961-8200. You can reach me on Skype at jim.hacking.3, or you can email us at jim@hackinglawpractice.com. If you like this video, be sure to click the like button, and if you want to get further updates when we update the website with new videos, make sure that you subscribe to our YouTube channel. Thanks a lot. Have a great day, and we hope to see you down the line.